Good evening, everybody here in the room at Garden Court. Welcome to this School Inclusion Project policy meeting. My name is Kate Aubrey-Johnson. I'm a member of Garden Court Chambers. I'm a barrister and I'm a mediator, and actually I also mediate SEN support, SEN disputes for kids send mediation. And I also convene the children's rights team here in Chambers. So I'm really delighted to be chairing tonight's event. The School Inclusion Project is a forum that was created by Garden Court's education law team, but it was started in partnership with Communities Empowerment Network, CEN, and Quorum Children's Legal Centre, along with the Law Centres Network. And the purpose of the School Inclusion Project was really because Garden wanted to be part of looking at various ways in which we could directly impact what we could see was happening at a time when Lives Matter became very at the forefront of our minds in terms of what's in the media and bombarding us. And we wanted to actively take steps to do something to address what's happening for young people in Britain now. And we didn't want to be complicit in standing by and not doing something. We wanted to be actively using our agency, our skills and aptitude in addressing what we see is disproportionate use of school exclusion. And of course, the word School Inclusion Project are all about the fact that what we really want to do is see school as inclusive spaces. The School Inclusion Project particularly wants to look at systemic discrimination within the education system, and it wants to use policy work and strategic litigation as a way of addressing that. And we want to be an opportunity to convene frontline organisations, policy professionals, legal practitioners, individuals who are impacted by school exclusion in order to be part of addressing key policy issues in this area. So I cannot thank you enough for coming along this evening. We've got a packed agenda, so I am going to turn first to Alice Livermore from Mind. I'm going to ask you, Alice, you're online, to introduce yourself if you can, letting the audience know a little bit more about you. And you're going to talk to us from Mind about access to child and adolescent mental health services in inpatient settings. Thank you so much to Alice.
Thanks so much, Kate. Thanks so much to the Social Inclusion Project for having me here to speak today. My name is Alice Livermore. I'm the head of legal at Mind. Mind is a national mental health charity covering England and Wales. Our work sort of focuses on mental health, and a lot of my work involves legislative reform, trying to improve the legal framework for people with mental health problems, and within that sometimes includes strategic litigation, particularly intervening. So Mind will look to intervene in cases where we think they are of particular importance and where the outcome is likely to have a broad and significant impact for those of us with mental health problems. And one of the cases that we support in a very small way is going to be discussed this evening. So I'm delighted to sort of be on the panel today. I'm going to be talking a little bit about CAMHS inpatient beds, and I'm going to be talking about the very confusing sort of processes in accessing them. I suppose I'm a bit of an outlier to the other speakers in that I'm not going to be talking about the education system, but nonetheless, the types of problems that children and young people face in accessing inpatient services, being left out of the system, struggling to access the support when they need it, early intervention support simply not being there. I think it shares a lot with sort of the experiences that many of you will have had in your professional lives. So I'm going to be talking about CAMHS inpatient beds, sometimes called Tier 4 beds, sometimes called CAMHS beds, and inevitably I'm going to end up using those terms interchangeably, but they are the same things. First of all, I just want to talk about sort of the numbers of children and young people that find themselves in inpatient wards every year. And I've shamelessly borrowed there from a title of a Children's Commissioner's report from a few years ago. Who are they? Where are they? Last year, there were 963 detentions under the Mental Health Act of people under 18 in hospital. But that's not the only children and young people who find themselves in inpatient settings. Now, whilst no data is published on the numbers of children admitted informally or held on paediatric wards, so physical health wards for mental health problems, the data from the Children's Commission suggests that about a third of informal admissions, a third of admissions for under 18s are actually informal. So sort of people that sort of exist outside the statistics that are being officially collected. And again, no data is actually sort of really sort of effectively published on this, but it does suggest that for children from Black and racialized communities, they are much more likely to be admitted through compulsory admission and much less likely to be admitted informally. A couple of years ago, Mind did a report into young people's experience of inpatient admission called Our Rights, Our Voices. And we found that young people's experience of inpatient care was overwhelmingly negative, and they described being inappropriately placed in adult wards, which was a very sort of scary experience for them, or very far from their homes, their communities, their families. They described experiencing or witnessing restraint, which was traumatizing or re-traumatizing, and they described being left to navigate a confusing system alone. And things often didn't get better when they were discharged because they were sort of promised support that never actually materialized in the community. And obviously, inpatient services exist within the sort of the broader children and adolescent mental health services. And what's been happening over the last few years is there has been a drive towards increasing community mental health services. And whilst I don't think it's official policy, there does certainly seem to be a move away from inpatient services. In 2019, NHS England made a very ambitious target of increasing access to NHS-funded community mental health services by 345,000 children and young people. Now, progress is being made towards those targets, but they're certainly not being met. And whilst that's happening, whilst there is sort of this push towards community services, what Mind has found in a recent FOI suggests that that's going alongside an overall decline in the total number of inpatient beds being commissioned for young people. And there's been a decrease in the numbers of children and young people who are being admitted informally. So you have this system going alongside each other where community services are increasing, they're not as increasing as much as they need to, and at the same time, the availability of inpatient beds is going down. So you have children and young people, perhaps with the highest levels of need, are sort of stuck in that they don't have the community-based services they need, but it's increasingly hard to actually access inpatient beds. Now, bear with me on the next slide, because I'm going to be talking a little bit about policy documents here, but I hope it is informative, at least at understanding what a tangled web there is in actually understanding how commissioning and access to CAMHS beds work. So right now in England, NHS England has overall responsibility for commissioning all mental health beds for under 18s, but this is imminently going to be delegated to integrated care boards. What happens at the moment is the NHS England regional teams contract with the NHS lead provider of a local provider collaborative. And a local provider collaborative is a non-legal entity that consists of groups of providers of beds. So that can be NHS facilities, it can be private facilities as well. So NHS England will contract with the lead provider, who will then subcontract with one of the providers within the provider collaborative whenever a bed is needed. It seemed pretty complex to me, but that's how things work at the moment. But when commissioning is delegated to integrated care boards, commissioning arrangements may remain the same, or they could be designed. So we have this possibility that actually this already quite complex process is going to become even more different at a local level once the delegation happens to the ICBs. But that's not the end of the story when it comes to actually getting a bed, because before a child and young person can be admitted to an inpatient bed, they need to go through something called the National Referral and Access Process, and they have something called an access assessment. And an access assessment, I don't think it's sort of a particularly unusual idea. It's basically a sort of an assessment which will determine what sort of bed the young person needs. And the aim is to sort of stop there being inappropriate or unsafe admissions. And access assessments, what they are is they are clinical policy documents. They're produced by NHS England, and it binds the practice of NHS England. What it's not is a statutory process. So you're not going to look in any sort of regulations, any primary legislation, and say, yes, this is the criteria. This is how I know if a young person is going to get a Tier 4 bed. And Mind doesn't have concerns with the access assessment process itself, but we have concerns that there have been various incidents where Mental Health Act assessments, which is the statutory process for determining whether someone needs detention for treatment or assessment in hospital, have been effectively overruled by access assessments. And that's really concerning because Mental Health Act assessments, they are a statutory process. They're completed by 3 medical professionals that have experience of mental health. And they determine, that as a last resort, a young person will need admission to hospital. And yet, in some cases, they're being overruled by what is effectively a policy document. And I've sort of referenced one case from a couple of years ago in which that's exactly what happened. And this is a case in which a young person with sort of very, very high level and complex needs who had made a suicide attempt, an application for assessment and for detention under the Mental Health Act was made, but an access assessment was completed and it determined that admission was not required. That the admission wasn't suitable for this young person. But what ended up happening for this young person is that ultimately the court had no option but to approve an authorisation of a deprivation of liberty in a social care placement that was not registered with Ofsted, where staff had described this young person as a wild animal and in which she'd been able to access knives, screwdrivers and medications. So on the one hand, you have a policy document saying no, inpatient admission not suitable, but I don't think where this young person ended up could it be described in any circumstances as suitable either, but there was simply no other place for the young person to go. So what happens if young people aren't admitted to hospitals? Well, in many cases, they will return to the family or home environments where hopefully they'll be supported by community CAMs. But what we know from what young people have told us and what we know from sort of the fact that NHS England isn't reaching its targets around community services, that's not necessarily going to happen. In many cases, that the care falls to the family members. They have to become caregivers for specialist mental health care, despite not being specialists in mental health. In some cases, children might end up staying on paediatric wards, so physical health wards, until they can be discharged home. And in the most extreme cases, such as the case that I've mentioned before, they may have to be deprived of their liberty in often unsuitable social care placements. And for those last 2 points, paediatric wards and deprivation of liberty orders, there's been an explosion in both over the last few years. So between 2012 and 2022, there was a 65% increase in the number of children and young people being admitted to general acute paediatric wards in England because of a mental health concern. So not primarily because of a physical health concern. And in a recent FOI that Mind did, we didn't get sort of really clear data on how many children were in paediatric wards, but we certainly did get an acknowledgement from several provider collaborators that yes, young people were sometimes experiencing extended stays on physical health wards simply because there were no Tier 4 beds available. In respect of the use of deprivation of liberty orders, again, there has been an explosion, I think sort of a 462% increase in their use over the last few years. And whilst access assessments don't come up in many of the judgments, issues with community and inpatient plans do. Now, the Nuffield Family Justice Observatory has done lots of research on this, and something they highlighted in one of their reports was that many of these young people have extremely complex needs, including mental health needs, and concerns are being raised by the courts, the children's guardians, the parents or carers, that these children just haven't been able to access mental health services at all at the time that they needed it. So what does Mind think could happen? Well, in our view, that there hasn't been any detailed consideration by the courts of whether Mental Health Act assessment actually can be overruled or circumvented by these policy documents in access assessments. But, the reality is that we need to ensure that children and young people who experience mental health crises can access the support in their communities when they need it. And one route to that, not necessarily the best route, is through amendment to the Mental Health Act, which is currently undergoing a period of reform. And 2 things that Mind has been calling for is a right to assessment and treatment for community-based services for children and young people, sort of based on perhaps Care Act duties, but sort of transforming them and bringing them into the NHS and sort of creating rights to assessment and treatment and support for mental health needs. And secondly, a duty on integrated care boards to ensure that there are sufficient community-based services for children and young people to reduce the need for detention. Another route and something else that is happening is through a national network of early support hubs to ensure that children and young people can receive timely mental health and wellbeing support when they need. And Mind is part of a coalition called the Children and Young People's Mental Health Coalition, and recently published a blueprint for what these types of hubs should look like. And there has been a sort of a bit of a positive reaction from the government in that respect. They've recently invested an additional £7 million into 24 hubs. But £7 million, it sounds a lot, but it doesn't really go that far. And these early support hubs, and there is good evidence suggests they stop some young people reaching crisis, but to truly make a difference, the amount of funding needs to be much bigger, and there needs to be support nationwide. And I think this is sort of the reality that we come back to in whatever field that we work in, is that any solution is going to be cost and resource intensive. But is the government actually in a position to prioritise funding for mental health services at the moment? Thanks so much.
Thank you so much, Alice. We have had a question which other people in the room may also want the answer to, which is, can you explain the difference between formal and informal hospital admissions?
Yes, absolutely. I'll do that quickly now, just rather so everyone can hear it. A formal admission is where you are detained under the Mental Health Act. So you're sectioned. It allows for compulsory admission and treatment, regardless of sort of your feelings about it. An informal admission is where you, or for children under 16, your parents may have consented for you to be admitted, and you are there on the basis of consent rather than sort of compulsory treatment or compulsory admission.
And I have a question, because I'm quite interested in, I come from a youth justice perspective, and interested about the use of deprivation of liberty orders for children, coming from the High Courts, the Family Court, the High Court, in the family divisions, inherent jurisdiction. So that's also being used for this group of vulnerable children who have got mental health needs. And am I right in saying that that really means that enables effectively the court to place them in unregulated settings if needed? Because there's a lack, not because that's what the court wants to do, but because the court's hands are tied, because there is a lack of placements that can meet these children's needs that are regulated.
Yes, I think there's sort of two things going on. That the main one is there's a national shortage of secure children's homes. But I think, and this is sort of perhaps more of a personal view, that I think is something quite as clearly set out, is that if there is a move away from inpatient beds, and if the total numbers of commissioned beds is going down, then inevitably that is another form of sort of restrictive placement that can provide therapeutic support to children, young people, that is increasingly being moved away from. But I don't think necessarily there are the community resources to support children, either that end up in secure children's homes or in inpatient settings. But yet these are the sort of the beds and the placements that are being cut and chipped away at.
And I'm going to take this as the last question. Is attempted suicide the primary means of deprivation of liberty? I think the question being, is that the primary cause of these children being subjected to that power to deprive their liberty?
I don't think so. I think there are sort of a range of different groups of children whose placements are being authorised in this way. So you have perhaps children with learning disabilities and autistic children, young people who have sort of a high level of needs, and it's a placement that everyone agrees with. You've got young people that are at risk of criminal exploitation or sexual exploitation. And you have perhaps a sort of a third group of children, young people who have experienced a great deal of trauma or have sort of high levels of mental health needs. I think probably all the children probably have some degree of sort of mental health needs, but I don't think it's right to say that suicide is the primary reason. I think so there are quite distinct groups within that, although some of the themes that come up are sort of incidents of self-harm and suicide. They are common features, but I don't think they're the primary reason.
Alice, that's fascinating. And I believe the Family Justice Council on the 1st of April is holding a whole conference about deprivation of liberty orders in Birmingham. If that's an area people are interested in, no doubt Alice will be there, and we will continue that discussion. So we are very lucky to have some leading lawyers who have been successful in the School Inclusions Project's ambition to bring strategic litigation to develop the law in relation to school inclusions and supporting our aspiration to keep children being educated in school. And we're joined here in person by Sabrina Simpson from Quorum Children's Legal Centre, and our very own Ollie Persey is online. And I believe, Sabrina, you're going to start talking about legal aid for school exclusion IRP hearings, an update following the judgment that you can tell us all about. And could you just introduce yourself to the people in the room, who very few of them won't know who you are, but if they don't, the people in our virtual meeting at home may also want to know a bit more about you.
Thank you. Good evening, everyone. It's an absolute privilege to be here today to share some good news at times when we're hearing about lots of injustice within society and many charities unfortunately closing, particularly within this space, who have been trailblazers in working behind the scenes. So I am an education solicitor at Quorum, Children's Legal Centre, and I also supervise a school exclusion clinic there. That's a pro bono clinic, which is run by the use of volunteer lawyers that support the work behind the scenes. I'm sure you'll recognise, but doing this type of work, which up until the 14th of February, there was no legal aid for, we were up against the pressure in terms of being able to represent children who are excluded. And within our case studies, we hear many cases of injustice. So thank you for that introduction. Before I go on to talk about the High Court case, which has now paved the way for exceptional case funding in independent review panel hearings, I just want to start that my daughter told me one day that I would go down in history. If it's due to this case, I must say I didn't do it alone. I'm going to start because it's important. I've got a long list here because, yeah, the work of school exclusion is so critical to education and ensuring a fair education for all. But there were people that saw the injustice that's gone on for many years within this field. And it was Alex Temple sitting next to me that had the initiative to even start the school exclusion clinic when he was a trainee solicitor at Just for Kids Law. Also, my main funder for school exclusions is Mission 44, whose founder is Lewis Hamilton, who himself experienced a school exclusion. There have been many volunteers and charities, both past and present, who have supported children excluded from school, and of course, the vital support of the School Inclusion Project, which I hope you're all part of, which is why you're here today. Also, my team at Quorum, some of them are here today, and I know some are online, who ensure this vital work continues, and also the school exclusion work expands both within this casework and also strategic litigation and policy, because we all know, the law is the end, but there's so much more to do in this field. The law firms who support this clinic and whose case studies were very much part of that fed into the witness statement that I wrote about really the historic trauma of the many children that have experienced school exclusions, and the case studies that we see, namely Alan Novi Sherman supported me within that. Also Mind, who intervened in this case, represented by Grace Brown and Nadia Amara, and obviously Alice, who you heard speak earlier. We also had the EHRC support this case. And last, I've got my list now, last but not least, got the phenomenal duo, Stephanie Harrison and Ollie Persey, who were the barristers on this trailblazing case. The last annual school exclusions data, there were 9,400 children permanently excluded. And the evidence from our case studies are overwhelming. Discrimination, unlawfulness, disproportionality, and injustice continues in school exclusion cases. All people will see statistics, but we see the many families who are heartbroken through this process, who many of our clients have special educational needs. We know that race discrimination occurs within this. We know adultification bias occurs. And we know that many children who are unfortunately go for a school exclusion are there not because it was a last resort, but because there was a lack of resources and a lack of support that went into support for children. As advocates, we are vital to safeguarding human rights and ensuring that public bodies act lawfully. And we really do need to recognise that, yes, this case has now opened doors, but we are going to need advocates within this space, one step to raise awareness, but also to make sure that this doesn't continue. Within the case that we did was one family's heartbreaking story of a child that had special educational needs, whose needs went unmet. who was punitively punished at school, who a lot of that was due to adultification bias, that they didn't see his special needs. He was a black boy, and instead he was punitively punished with many suspensions, isolations, and of course, all of this really just disadvantaged him and impacted his mental health. This one's family's trauma reflects the many families' trauma that I've heard along the way. Children who've been victims of bullying, children who very clearly had special needs, but they were told, sorry, lack of resources, we're not going to put in any support via an educational healthcare plan, or sorry, the waiting list is too long, sorry, we wish we could have done more, but oh well. These are the type of children that are excluded, not children who deserve to be permanently excluded. I have a question for you now. And it's really lovely to see actually people that I know from the room, I know have taken on cases before there was even legal aid available now for sexual harassment. Thank you all who have been part of this very long process. And I'm looking forward to a better future and a fair education for all. But I do have some questions for you. And it's, will you be silent knowing that there is a severe risk that children are being unlawfully excluded and discriminated for exclusions? Because we all go to good talks and hear good talks, and we can go back to our work and go, we've got too much work to do. I can't get involved in this. Will we continue like this? And if we represent schools and public bodies, will we win at all costs? Or will we ensure that the bodies that we are representing are acting lawfully and school exclusions are only used as a last resort? My last question is, exceptional case funding is now available, and Ollie's going to talk a bit more about that. But will you represent the family to ensure that we have a fairer education?
One question. So the question is, can anyone in London access the school exclusion clinic if their child is being excluded? And this is the Quorum School Exclusion Clinic.
So good question, because I did actually have that slide up at the end. So yes, anybody can go to that resource, and that resource serves two purposes. It is to make a referral to this clinic for free representation, but it's also has all the information and resources for advocates as well, and templates and slides about how to challenge school exclusions, both at governing body level and at independent review panel level as well.
So I hope that answers Yasmin's question, and we turn online to Ollie and Steph, who are going to talk to some slides. Thank you so much, Ollie.
Thanks very much, everyone. So I'm going to talk through what I think are the main implications of the recent judgment of the High Court in CWJ against Director of Legal Aid Casework and Lord Chancellor, in which Mind intervened. And very briefly, and without wanting to go into too much technical detail, because I think I got given a 6-minute slot, is when we started this litigation back in 2022, there was a categorical ban on exceptional case funding, the legal aid safety net, applying in independent review panels. Now, we didn't think that was right. We thought that was a misapplication of a Court of Appeal case called Tom Hood, and we thought there was a potential for Article 6, the right to a fair hearing, to apply in an independent review panel hearing. And our view was discrimination concerned civil and political rights, civil rights and obligations. As such, where you're alleging discrimination, there is a determination of a civil right and obligation by the independent review panel. And as such, Article 6 is engaged. Now, where a convention right is being engaged, that creates the risk of breach if someone can't properly participate. So that brings into play what's called the exceptional case funding criteria, which is the safety net for areas of law that aren't in scope for legal aid, which unfortunately this is an area that is out of scope for legal aid. But before this litigation, the Lord Chancellor's position was effectively it's out of scope for exceptional case funding as well. So you can see the position at paragraph 54 was the pre-CWJ litigation position. The guidance below is not complete or particularly adequate, but was a move forward and an opening of the gateway that happened after we lodged our claim. So this happened in 2023. Reminder, we got our judgment in 2025. We lodged in 2022. This case dragged on. But what's really interesting from the judgment is, in a nutshell, what the judgment says and lays the foundations for is 2 gateways for getting exceptional case funding. One, where you have a substantive, so not procedural, not the public sector equality duty, but substantive, so direct discrimination, indirect discrimination, harassment, failure to make reasonable adjustments, this sort of material, substantive provisions of the Equality Act 2010. Our big fight with the legal aid agency was whether the independent review panel, rather than a court or tribunal, could determine allegations of breaches of those duties. And on that point of principle, we won. And the key paragraphs are at 148 to 156 of the judgment and make clear that a directly decisive determination of those obligations can be made by the independent review panel. And as such, that engages Article 6. And as such, in our view, that brings in the legal aid safety net, which, as Sabrina has mentioned in her presentation, anyone that's done any of these cases knows that overwhelmingly there are issues about unmet special educational needs. There's issues of race discrimination, adultification bias, etc. So that clearly engages the substantive provisions in the Equality Act, and where an application is going to be made for an independent review panel hearing on the basis it's discriminatory, the exclusion was discriminatory, we think there is a good basis where, if without representation, the family wouldn't be able to fairly participate in that process, be that because emotional connection to the material, they might be, family members might have a disability themselves, caring responsibilities, whatever it might be. We think there are good arguments for a lot of the cases that come through the School Inclusion Project to get exceptional case funding going forwards. So that's Gateway 1, substantive Equality Act breach. But there's also a determination of this is a bit circular, but a determination of a human rights argument. So if you alleging that there's a breach of, for example, and this is something Alex will talk about later, the protection duty in relation to child criminal exploitation under Article 4 ECHR at an IRP, that IRP is making a decisive determination of whether there's been a breach of that human right. That determination, in turn, engages Article 6, the right to the fair hearing. So there is now a clear pathway that the IRP is making decisive determinations of civil rights and obligations, and this safety net now needs to apply. And this is a huge step forward from the categorical prohibition on Article 6 not being engaged, which we saw in the 2021 Lord Chancellor's guidance. And so there are lots of more arguments to be made. This is not an exhaustive list, but there's real potential to get exceptional case funding going forwards. So what are we trying to do about this? We're trying to implement this judgment so that we can actually get access to justice going forward. This is a big dent, but it's only a dent so far. We haven't actually had a grant of exceptional case funding, but we think we're on the cusp because of the steps we've made forward in this case. So we're going to be providing further training on exclusions for legal aid contract holders. We've been in touch with lots already, like generalist public lawyers, education specialists, about applying for exceptional case funding. We're putting together a template, and so that people can sort of tick the boxes. When we were applying previously, we're sort of shooting in the dark because no one had done it before. Now we have guidance from the High Court how to meet the criteria, and we think, subject to the legal aid agency complying with this judgment and the guidance in this judgment, we should be able to get to exceptional case funding in a lot of cases. Then we're going to make lots of ECF applications and monitor the legal aid agency's decision making. And it's our suspicion that the legal aid agency will not make decisions well, and certainly not quickly. And anyone that does this area of work will know that there is a very fast turnaround in the governing body, then independent review panel process, in theory. You're talking 15 school days, a short period. ECF applications can take months to determine. Now, if the Lord Chancellor can't put in place a system to grant ECF quickly, then there's potentially an opportunity to apply pressure for it to be brought into scope for legal aid, which is the key aim, so that actually you don't need to go through this exceptional case funding criteria at all. But we've got lots of solicitors who have very kindly agreed to take on one or two of these independent review panel ECF applications at risk. So we're going to be building that evidence base now with a view to showing actually ECF really should just be brought into scope for representation in school exclusions. Now, there's another interesting point. Don't have time to go into it now, but Article 6 ECHR brings with it some procedural protections. It's not just ECF, and anyone that does independent review panels may well have experienced a wild west of ridiculous procedural unfairness. For example, granting applications to adjourn just because the school wants to. The independent review panel being convened by the academy where the kid has been excluded from, and that's an academy of one, not a multi-academy trust. Query how that is independent. So I think there's a lot of interesting work we can do, not just in relation to legal aid, but with this principle in relation to Article 6. So thank you so much, everyone, for coming. Thank you for your interest.
And as may have started to become apparent to those of you in the room, that this is a significant and fantastic win that we all need to celebrate, because there aren't wins every day, and there are a lot of frustrating days when you don't get the outcome you're looking for. So I think we all are going to share in this victory. But thank you, because the other thing that's abundantly apparent is that these victories are hard fought, and huge amounts of work is done behind the scenes and long before the case even starts to be litigated, to create the environment into which such cases are won. There are some questions, Ollie, and I'm going to turn to them. One of them is, how persuasive is the UNCRPD Article 24 in school exclusion cases? And for those of you, and I'm always careful with acronyms because we fall into the habit of using them, assuming everybody knows what we're talking about. The UNCRPD stands for the UN Convention on the Rights of Persons with Disabilities, and Article 24 is the right to education. Do you want to answer that, Ollie, since you're on the screen here?
Sure. I mean, without wanting to get too lawyerly and technical about it, I'm conscious it's a mixed audience. In relation to European Convention rights, there's an approach of harmonious interpretation with international treaties. So you can read the substantive you would typically run in applying the Newlinger principle in harmony with the UNCRPD, UNCRC, etc. And so I think there are certainly ripe arguments to be made about adding nuance to sort of Article 8 arguments around actually how, and this is something Mind evidence was really powerful on in the intervention, about the impact on the mental health of permanent exclusion and the Article 8 impact. But like, read Article 2 of Protocol 1 with the UNCRPD and Article 8 with the UNCRPD. It adds sort of nuance and sort of specificity when you have a harmonious reading like that. So that would be the approach I would take, but there are obviously other ways of dealing with it too.
Thank you, Ollie. And in fact, I'm reminded I missed a question earlier, and apologies for missing this, but before we lose Alice from Mind, there was a question about on how, on average, how long are young people kept for? And I think this was either in hospital, in those detentions, or under Dole's orders. Is there an indication you can share with the room about how long these children are kept either in hospital or under Dole's orders?
Yeah, so I had a quick look at the sort of Mental Health Act annual statistics, and they're pretty hard to figure out. But again, data that the Children's Commissioner pulled together in 2020 suggests that on average, young people are there for about 3 months, but the most common sort of length of admission is 2 months. So what that means is that some young people are there for much, much longer, which is driving up the overall average. But for most young people, they'll be there for a couple of months. When it comes to deprivation of liberty orders, I think that can be much longer, but I don't have any data on that, unfortunately.
Thank you very much. The next question is, as a teacher, Senko, and author of a book on inclusion, I've learned that exclusion starts right at the beginning of children's lives, before the resources to assess, send and provide appropriate interventions are so restricted. So I think that's a statement, and that's I think it's more recognizing that there are factors that start much earlier in their lives, where early intervention through other sectors before the education system commences in these children's lives. So thank you very much for sharing that. And in terms of the question that was asked, it was a question about detention for mental health, where a child would have learning disabilities, and that was to do with the use of deprivation of liberty orders. And that would be a situation where a deprivation of liberty order was necessary for a type of social care placement. I think I've read that correctly. A child with learning disability cannot be detained under the Mental Health Act in inpatient care unless their disability is also associated with abnormally aggressive or seriously responsible conduct. But this is something that may be subject to reforms under the Mental Health Act reforms. So thank you, Alice, for sharing that answer. Thank you to Sabrina and Ollie. And now I'm going to turn to another one of our online contributors, Briony Elliot from CLISA, to talk about rebuilding relationships between children and schools. Thank you very much.
Hello, thank you. Thank you for the introduction and very much for having me. I'm sorry that I can't be there in person. I know some of my colleagues are, but yes, I have been in schools today, so that's why I'm joining online, and hopefully can bring some of that energy from young people that are sharing their experiences of some of those difficulties as well. So yes, my name is Briony Elliot. I am a senior program manager at CLISA, and I oversee the adults delivery. So I'll be talking a little bit about the programs that we offer. I'm also a practicing drama therapist, so I'll be bringing some of that therapeutic thinking into this presentation, and approach with rebuilding relationships between young people and schools. So this evening, I'll be introducing each program that we offer, looking at some of the challenges that we experience alongside the learning that we've taken from these, and really spreading the work that we do here at CLISA. So who we are, so CLISA means to nurture in Zulu. So our programs and methodology originate from our founding sister charity in South Africa, which was established back in 1997. CLISA's Face It program model is unique in that it uses therapeutic and creative methods to improve the emotional well-being of high-risk young people who are at risk of exclusion, exploitation, disengagement, and being drawn into crime or violence. So our work views challenging and antisocial behaviour as a form of communication. So really looking beyond the behaviour to understand its cause. And by exploring past experiences, teaching emotional literacy and building resilience and well-being, we provide young people with the social and emotional skills they need to transform their lives. We focus on addressing the root causes of behaviour rather than merely managing symptoms. So moving on to looking at our Face It programme, which is the young people's element. So the Face It programme is a trauma-informed psycho-educational initiative which uses creative therapies alongside neuroscience. So it's multimodal, employing art, drama and storytelling, neurosequential, focusing on emotional regulation before reasoning, and therapeutic, emphasising safety, boundaries and rituals. So the programme is adaptive, meeting the specific needs of each group while fostering emotional literacy and resilience. So moving into some of the challenges that we face. So young people are identified and referred by school staff based on specific criteria, such as behavioural challenges, emotional difficulties or vulnerability. We work closely with schools to ensure that the young people who would benefit most from the programme are included. But we still do find that often on referral forms, young people are not informed of why they have been selected and will often challenge us around this. So asking, is this for anger management or challenging behaviour? And we really have to spend time presenting this as an opportunity, but we're often working with schools to increase their open communication and transparency with young people, which we know is also a huge part of trauma-informed working. Leading on from this, we're often questioned by schools around our expectations of behaviour within the programme. So we know from a therapeutic perspective that it's imperative that we work with the whole child and not just parts of their character. And group dynamics are often complex, and we will often see the group move into the storming phase in group dynamics where challenge and conflict often takes place. We believe that behaviour is a form of communication. Use this as an opportunity to explore underlying issues. And our facilitators are trained to manage disruptions therapeutically, focusing on de-escalation and emotional regulation. We also use this within the activities that we explore on the programme. So, for example, you'll be able to see in one of the pictures on the slide. So we explore the concept of masks on the programme, where the group are introduced to a metaphorical poem and then given creative freedom in decorating a mask. So we encourage them to consider what masks they may put up to protect themselves, and also introduce them to the concept of the true self which lies underneath those masks. This part of the programme is often a huge highlight for young people. We use projection as a technique for them to express different parts of themselves. So sometimes they may name parts that they don't like or that they don't feel seen, or sometimes it might be based on a character or colours. And through the use of the mask, they have a way to build awareness of those parts. So find ways to accept or name them, or also distance themselves too. So it's giving them a way of showing a me, but not me, in whatever way that feels comfortable for them. And by using their hands creatively, we're incorporating the body too. We know that when trauma takes place, it can often split off the brain and the body. And so in all of our activities, we're coming from a place of gently incorporating the whole self. Often what we're able to share with schools following that session can be really powerful in the school thinking about how they interact with students. So students will often express that they feel that they're only seen for their behaviour or have been demonised for previous incidents. And CALISA staff can really act as that bridge for challenging those approaches, ensuring that each student is seen as an individual and is valued for all that they have to offer, working towards collaboration and students feeling that schools are making decisions alongside them rather than students feeling like they are being done to. So we also offer a trauma training programme for education staff. So our trauma training programme consists of 5 two-hour sessions aimed at building staff awareness of trauma-informed principles and practice and the importance of their own self-care. So this includes enhancing staff's understanding of trauma-informed principles and practices, exploring the critical importance of self-care for professionals in what we know is an increasingly pressurised context, equipping teams with essential knowledge and strategies for effective practice in the classroom. And within each session, we concentrate on a specific focus area to empower professionals with the knowledge, skills and practice they need to support the young people they're working with. So the sessions support them to regulate their own emotions and understand the people they are working with better. So the trainees will be applying effective educating strategies that are rooted in trauma-informed, person-centred and anti-oppressive principles. looking at some of the challenges and learnings that we find within that. So parts of the feedback from teaching staff is that they are really keen for strategies, approaches and practical elements to use. And whilst we understand and appreciate the keenness and questioning of how do we put this into practice, we know that being trauma responsive goes beyond being trauma informed. And this is what we would like all of our partners to be working towards. When the theory around trauma is fully embedded into education staff's practice, it becomes a way of being and is used within all interactions with students and staff, rather than just focusing on those that we know have experienced trauma. We also sometimes observe a reluctance from teaching staff to look inwards and engage in reflective practice, considering what might be triggering for them in interactions with young people, or what young people might be bringing up for them, which could be causing both teacher and student to get stuck in cycles of conflict with one another. And how can we, as Kalisa, support both parties to step back and see where they can make changes moving forwards? One of the challenges that we're always up against is when we can book this in. So we want education staff to have time to practice, reflect and come back to subsequent trainings. But we have to appreciate that often, if these are facilitated in twilight sessions, staff can be very fatigued, and the intensity of the theory around this can understandably feel particularly heavy as well. So again, this can make creating safe spaces difficult, in which we are able to develop those meaningful relationships to then be that critical friend within the partnership. Touching on some of the follow-up questions that we receive, so that can show how current policy can often feel as if it contradicts trauma-informed practice somewhat as well. So a question that I was asked recently following a trauma training session was consistency versus empathy. Is this possible? So my follow-up answer was explaining how it might feel as if the two contradict one another in terms of behaviour management, but the two do work together. Consistency provides structure and boundaries, and empathy is ensuring that individuals feel heard, understood, valued and supported. And we come back to therapeutic parenting theory a lot, which uses the idea of high boundaries, high nurture. So whilst clear expectations are communicated, empathy is role modelled and demonstrated through personalised student approaches and restorative practices. Touching on restorative practice, so sometimes we can come up against the concept that restorative practice can be seen to excuse behaviour, but we have to keep pushing back and explaining that this is in fact quite the opposite. So restorative practice holds students to high standards with kindness, warmth and care. We never excuse unacceptable behaviour, but we address the underlying causes and support students to move on from it with the learning of what they can do differently next time. And ultimately, we know that it pulls students in rather than pushing them out. So accepting the emotions, fueling the behaviour is not the same as accepting the behaviour. And being empathetic is not rewarding the behaviour. And what I often explain to schools is that often how students are being spoken to in some exchanges isn't something that we would tolerate within our own workplaces. Yes, we may have to implement consequences at times, but how do we do that in a way that's measured and from a place where we are responding rather than reacting? And then moving on to our parent and carer offer. So this is our Nurturing Connections programme. So this is not a programme teaching parents and carers how to parent. We know that they are doing a great job, but we just understand that this period can be particularly difficult for young people who have experienced trauma or adversity, placing them at an increased risk of exclusion and making them more vulnerable to negative influences. So our programme equips parents and carers with practical knowledge, skills and attitudes essential for nurturing their child's well-being, emotional development and behaviour. We focus on reducing feelings of isolation and providing the necessary support to help parents and carers regulate their emotions, understand their children better and apply effective parenting strategies that are rooted in trauma-informed attachment and attachment-aware principles. Many parents and carers struggle with gaps in knowledge, accessing support and managing their own well-being due to capacity and financial constraints, lack of self-care and social isolation. So our programme is designed to address these challenges by equipping parents with the skills and support they need to care for their own well-being and effectively then be able to support their child's social and emotional development during this critical period. So each session follows a consistent sequence that emphasises 3 key areas. So looking at parental carer wellbeing, understanding the teenage brain, and parenting carer support. So this structure helps parents and carers navigate the complexities of parenting with confidence and effectiveness. Again, just touching on some of the challenges that we face. So demystifying that this is not a how to parent programme really is ongoing. And I think this will take time to really establish this offer before we feel that we have moved through this. So even just recently, I was asked, is this programme only for young people with challenging behaviour? And whilst we use schools to promote the programme, we also no longer solely rely on this. So we give leaflets and letters directly to young people to pass on as an invitation and invite parents and carers along to coffee mornings to build rapport, answer any questions alongside dispelling any potential myths around what this is. And we've learned that we need significant amounts of time to drive up engagement. So attending parent carer evenings, encouraging young people to spread the word too. We know that parents and carers will often focus on the young person within their healing journey, but we really want to offer a space that will give themselves permission to take that up too. So we spoke to some of our young influencers as well around what they feel that schools can do to be more inclusive and to really kind of rebuild their relationships. I won't go kind of through all of what they've shared, but you'll obviously get the slides afterwards. But I think again it really highlights, you know, how young people are feeling that they want to be worked alongside rather than feeling that they're done to. So something as well really, really powerful in the part around sometimes it seems like things are decided about us without us, and really kind of wanting to be, you know, kind of more consulted around decisions that really affects them, of how they can be a part of that as well. And again, another young person who was really kind of voicing how schools, you know, really need to do more to be these community hubs as well, and what they feel that schools can do to like I said, just really create those inclusive spaces for them to be able to be, you know, so much more than sometimes, you know, what young people feel that they are able to access within them as well. Thank you very much. I'm more than happy to answer any questions, or myself and my colleague Isabel as well will also be happy to answer any follow-up questions as well after today's session.
Wow, thank you so much, Briony. Again, really wonderful to hear about positive work being done in the schools. And I can see that there's an online discussion with Ollie answering questions that have been raised. One of them is about PSED. If anybody wants to know what PSED stands for, it's the Public Sector Equality Duty. And so thank you so much, Briony, for your contribution. So I'm going to turn now to our next speaker, who is in the room. And we've talked about the reason really why the School Inclusion Programme project set up was because it was part of recognising that Black and racialised children are discriminated against, they get less good outcomes, they're excluded more frequently than their white peers. But within that group of this racialised minority are really significantly discriminated against group. And I'm delighted that we have got Shaun here from the Traveller Movement to talk about the work that the Traveller Movement have been doing and has been reported on through their Fought Not Taught report. What brilliant titles these innovative organisations come up with. So thank you very much, Shaun Mongan from the Traveller Movement, for sharing this report with us and its findings.
Hi, everyone. Thanks for inviting me to speak today as well. As you heard, my name's Shaun Mongan. I'm the Education Policy Officer at the Traveller Movement, and I'm a young Irish traveller myself. Apologies, I don't actually have any slides today, so unfortunately you have to settle with looking at me for 10 minutes or so. Someone to say, no, sorry, you're so handsome. Yeah, as you heard, we recently released a report titled Fought Not Taught. I believe some of you, or one of you, was there at the launch today. So before I actually go over the content and findings of the report, I wanted to give you some statistics briefly that kind of highlight like the issues at hand. So Briony, Gypsy, Roma and Irish traveller people have the lowest attainment of all ethnic groups across all key stages. At primary school, only 18% of Gypsy/Roma and 21% of Irish traveller children achieve the expected standard of development in comparison with 65% of all ethnic groups. This is even worse at GCSE level. Summer 2023 figures show that only 16% of Briony, Gypsy and Roma and 31% of Irish travellers attained GCSEs in English and Maths grade 4 or above. This is what the DfE describes as a standard pass. This again was the lowest percentage of all ethnic groups. These communities are also the least likely to continue into education past GCSE level. This low attainment goes hand in hand with the high levels of exclusions, elective homeschooling, and rates of absences amongst children from these communities. In addition to this, and as was concluded in the Timpson review of school exclusions, certain characteristics leave children at higher risk of being excluded, but that risk is greatest when an individual has overlapping risk factors such as ethnicity and SEND. SEND is another measure in which children from our communities are overrepresented. For Briony, Gypsy, Roma and Irish traveller children, educational settings are often where they experience bullying, punitive school policies and low expectations based solely on their ethnicity. Using the knowledge of this, the report we produced identified and defined institutionally coerced exclusions and its mechanisms. An institutionally coerced exclusion is a term used by the traveller movement to describe how schools, either through action or inaction, create a persistently toxic educational environment, forcing children and their families to withdraw from formal educational environments. This exclusion may not necessarily involve formal expulsion or suspension, but rather the creation of conditions to make it untenable or unsafe for Briony, Gypsy, Roma and Irish traveller children to remain enrolled in the school. Further to this, it does include the behavioural management systems and formal exclusion processes which are disproportionately used against children from these communities. The term acknowledges the systemic issues within the educational system that marginalise or discriminate against Briony, Gypsy, Roma and Irish traveller communities, and schools are even sometimes unaware that these communities are distinct ethnic groups with protection under the Equality Act. So I'm not sure how we're doing for time, but I'm going to go over some of the mechanisms, and in that way, you have to read the report as well to find out the rest of them. The first one we called institutional indifference. This is defined as an ignorance that is not one of blissful unawareness or innocent absence of knowledge, but rather rational calculation. We see examples of this. One example of this is that despite numerous governmental departments, research papers, and international organisations calling for a whole governmental action to tackle disparities, there's been no such action taken. This can be seen at the root of the disenfranchisement of Briony, Gypsy, Roma and Irish traveller communities, with many of those in power acknowledging the extent of the inequalities faced by these communities and yet failing to address them. We see treating ethnicity as a risk factor. This is a trend that we identified in educational settings, amongst those in educational settings who seem to regard the cultures and traditions of Briony, Gypsy, Roma and Irish traveller people as a risk factor and a liability to the development and growth of an individual. Examples of this include children from these communities often being seen as a risk to schools' ranking and success in league tables and such measures, or teachers being quick to label children from these communities as difficult. We see low teacher expectations. This is a theme we have identified across casework and wider policy work. I'm sure you'll all be aware that the research shows that the expectations that teachers have for students are often formed by their views on children's race, ethnicity, gender, and other protected characteristics have a significant effect on that child's likelihood to achieve. And this is always informed by biases held. Children from our communities are consistently subject to these biases. We also see cultural barriers versus school structures. There are key clashes between the priorities of mainstream education and the priorities of Briony, Gypsy, Roma and Irish traveller communities. And due to a lack of flexibility, families from these communities are feeling as though they must choose between education and maintaining their culture and heritage, which they believe is being eroded little by little. These communities also feel as though their culture, heritage and history are absent from the curriculum. This is crucial to address as a sense of belonging plays an essential role in a child's engagement and experience in education. There's language and low literacy rates. Low literacy rates are common among adults from these communities, with some studies suggesting up to a 62% illiteracy rate. This means that form filling, communicating by email, or reading letters can be very difficult for parents, and certain help is not available to their children, such as assistance with homework. Accessing core services can be impossible for some members of these communities, and this issue is compounded for Roma parents, with English often being their third, fourth, or fifth language. Schools and other public services would therefore communicate in ways which are completely inaccessible for many Romani, Gypsy, Roma and Irish traveller parents, with very little outreach made to the families if they are seen as disengaged. This always seems to manifest in the mantra that these communities are hard to reach. To the nomadic lifestyle. It's a common misconception that Romani, Gypsy, Roma and Irish traveller communities are predominantly mobile in the 21st century. Successive legislative changes have made it difficult, if not impossible, to continue the traditional way of life. For those who do wish to continue in education and engage in a nomadic lifestyle, the current format of mainstream education is not conducive to this. Richard O'Neill, a prominent storyteller and English gypsy, spoke about these difficulties, theorising that school is generally linear and travelling people have a nomadic culture and are generally more circular in their thinking and doing. Often schools and educational institutes are not open to altering the curriculum or the manner of teaching to facilitate these cultural differences, forcing many Romani, Gypsy and Irish traveller families to opt for home education. P code, which permits Romani, Gypsy, Roma and Irish traveller communities to travel for work without facing fines for non-attendance, is a vital protection of their cultural practices. However, recent updates to the attendance guidance has removed specific references to these ethnic groups, replacing them with the more generic term, mobile child. While this may seem like a minor change, failure to identify the ethnic communities explicitly contributes to a growing sense of erasure within these communities. Cultural expectations and fear of assimilation. What is seen to be valuable and valued for young people in Romani, Gypsy, Roma and Irish travel, for young people in these communities is often incompatible with what is valuable for educational institutions. The Traveller Movement's Road to Success report highlighted this clash, finding that many Romani, Gypsy, Roma and Irish traveller young people view the education system as it stands as being incompatible with the lives they lead. There are strong social and family expectations to work in particular forms of employment. For boys and men, this is often work in the family business or being self-employed. Self-employment has been a cultural tradition within Romani, Gypsy and Irish traveller communities for centuries. It's what most young people are familiar with. These cultural expectations can contribute to the fear of assimilation that these communities already have, following the failure of educators to facilitate any break from the one-size-fits-all approach, as well as the experience of state institutions attempting to civilise them through legislation and the slow criminalisation of a way of life, which culminated in the Police Crime Sentences and Courts Act of 2022. They're just some of the mechanisms of what we call coercive exclusion. So now I'm going to go over the key recommendations that we made in our paper. We recommended that the Department for Education must develop a statutory framework to ensure that all incidents of racism and racist bullying in schools are monitored, reported centrally to both the DFE and relevant local authority. The DFE must also ensure a race, equality and diversity policy is made a statutory element of the public sector equality duty for all schools. The DFE must reinstate specific references to Romani, Gypsy, Roma and Irish traveller communities in the attendance guidance, including the T code, which allows these communities to travel for work without penalties for non-attendance. The recent shift to the generic term mobile child diminishes the recognition of these ethnic groups' unique cultural practices and contributes to their erasure. Clear specific references to Romani, Gypsy, Roma and Irish traveller children should be maintained to ensure that schools are aware of the distinct needs and protections of these ethnic communities. The DFE should require all schools to revise their behaviour and safeguarding policies to explicitly address race and ethnicity, with specific guidance on supporting Romani, Gypsy, Roma and Irish traveller pupils. This should be mandatory training. This should include mandatory training for staff on these communities' cultural heritage, their legal protection under the Equality Act, and the unique challenges they face in the education system. Schools should develop tailored support systems for Romani, Gypsy, Roma and Irish traveller pupils, including academic support, access to mental health services and pastoral care, and family engagement initiatives. Local authorities must also provide resources and guidance to schools on fostering positive relationships with these communities to prevent disengagement and to ensure improved educational outcomes. I'm currently leading engagement sessions on solutions for coercive exclusions. So if anybody's interested, please ask my email afterwards. And this will be used as part of our second follow-up report on coercive exclusion, which is looking to be released in July. That's all.
Thank you so much. I don't know if anybody's got any questions. I mean, that is such important research because those are terrifying figures in terms of the discriminatory impact of the access to education or lack of it for children from Gypsy, Roma and traveller families, and it's just shocking to hear spelt out like that. And it's a common occurrence from youth justice perspective that you see such discrimination against Black and racialised communities all first group of children are always Gypsy, Roma and traveller children, and I'm so pleased that they have got somebody fighting for them and standing up for their rights. And I think when we have an opportunity to speak afterwards, we can all talk about ways in which we can all work together to amplify your report and make sure that it gets to the places that it needs to be heard. So thank you for that work. We have a question in the room. Thank you.
I was just going to ask, is there anywhere where you know of good practice or places that are already implementing some of the things, especially like local authorities that are working with their schools on these kinds of things?
Yeah, there's actually, believe it or not, good examples out there. I know everything I said was quite depressing there. We do list them in the report. We work in our steering group. There's like a lot of like head teachers from different schools, like director of education from, especially like around Derby as well, and Bradford. But there is good examples. I will get the details for them if you want them. But there definitely is good examples out there.
Great to hear. Thank you. That was a really good question. So I'm now going to turn to Alex Temple, who's going to talk about child criminal exploitation and school exclusions. Thank you, Alex.
Thank you very much. As Kate said, I'm talking about child criminal exploitation, or CCE, and the recent High Court's judicial review case and the appeal in RWU, the Academy. And there's three things I want to talk about. So the first is the background and a little bit of information about CCE. The second, of course, the case and the appeal. And the third, and I think most important, is what comes afterwards, because the case has opened some doors, and we now need to know how we can push on them and what might be achieved by pushing on them. So that's, I think, what I would like people to take away, if anything, from this. So the background is very straightforward. CCE stands for child criminal exploitation. It is an incredibly dangerous and pernicious criminal practice in which young people, children and young people, are manipulated, threatened, coerced into engaging in criminal activity, often in the drugs trade. And they are often the people who come into contact with the criminal justice system the most, or first, despite the fact that they are themselves victims of a crime, rather than simple perpetrators. It is on the rise. We've talked and heard a lot in the media about so-called county lines exploitation, which is a really common form of criminal exploitation in which young people are coerced into trafficking drugs across county lines, as the name would suggest. It is pernicious and incredibly difficult to stop, not least because the victims themselves are highly motivated not to come forward, even when faced with the prospect of criminal prosecution or physical harm to themselves. Because of the threat to themselves and to their families, they want to stay quiet as much as possible, and they're more scared generally of their abusers than they are of what the state will do to them. And that means it's really hard to break the cycle, particularly because it starts very early, and often it's been in place a long time by the time it comes to the attention of the authorities. And most tragically, it can be very dangerous and it can be deadly. Children die being criminally exploited. So the fact that it's on the increase, the fact that it's so serious, makes it, of course, an issue that should be of high priority to anyone working with children and young people. And this is where we come in as education practitioners, because it forms a part of the school to prison pipeline, in which children are permanently excluded from school and find themselves eventually in contact with the criminal justice system. Because, of course, so often the things that they are being exploited to do are things that are going to lead to their exclusion. And then once they have been excluded from school, they are more vulnerable to the people who would exploit them, because they have more time out of school, they've got less supervision, they don't have that protective factor. And you don't need to take this from me or anyone else who would campaign on this subject, or might be lefties or whatever. These are all things that are recognised by the police, by the Home Office. These are not in dispute. This is simply a matter of fact. So that brings us to the claim in RWU v. Academy. This was a young person, or considered a young person, who was permanently excluded from school for having some drugs on them on school property and some cash, immediately suspicious. But the school knew much more about their background and the warning signs that they had that they were in the throes of criminal exploitation. And these were signs that were, if you read the judgment, relayed by the judge, Justice Fordham, who said, for example, that this is a boy who had a really bright future ahead of them, who'd been recognised by the Academy to be doing well and to be capable of academic achievement, but who had exhibited a very sudden and dramatic change in their behaviour, a negative change in their behaviour. that was out of character for them. And that coincided with their mother being away, which out of the country, and she was a protective factor for him. He started exhibiting very serious tiredness, failures to stay awake in school, again, out of character to him. His attendance declined. He was having contact with the police, and they saw what they saw as a new life outside of school. His age, gender, and race were all indicators of susceptibility to CCE, and he also suffered multiple stab wounds. But there is dispute as to whether or not the school knew or ought to have known about that at the time. Further signs would come to light after his exclusion, but we'll get to that in a moment. And he eventually did get what we call a positive reasonable grounds decision from the National Referral Mechanism. The National Referral Mechanism being the arm of the government which independently assesses whether or not a person is a victim of criminal exploitation, which is hugely important, particularly for those facing criminal prosecution, because it might lead to a defence under the Modern Slavery Act. But that defence does not cross over into school exclusion. You have no protection under the law. Well, whether or not you have protection under the law actually is what this case is about, but no statutory particular protection under the law. So what the case concerned, among other things, is whether or not the school had a duty under Article 4, European Convention, which is the freedom from slavery, which includes both obviously the negative duties on a state not to allow someone to subject someone to modern slavery, or to prosecute someone for actions they committed whilst they were a victim of modern slavery, but also the positive actions, which is relevant here, which includes the duty to protect. So the duty to protect, claimant said, meant that the school should not have excluded him in the circumstances, or at least they needed to consider whether or not the duty to protect meant that they could exclude them. The duty to protect is triggered on a very low threshold of credible suspicion. And the reason for that is very good. It's because I mentioned earlier, it's a pernicious practice. It's hard to spot. It's hard to tackle. And so you need to be very alive and aware. And a school is uniquely well placed to be aware of these factors because they see a child every day. They're the only statutory service that's going to see a child every single day for that amount of time, and be able to spot trends and things like this. So there's two things to flag in the judgment, bearing in mind I have very limited time. The first is what the court said about the principles, and this is the good news. So the good news is the court basically did say that the principle exists, that a school, well, I'll just read it, from paragraph 61, I can agree that opponent's exclusion decision should only be taken compatibly with the duty owed by the school to the pupil by reason of the Human Rights Act 98. And I would also agree that a governing body could not fail to reinstate if, by the time of its consideration or reconsideration of reinstatement, an HRA duty was owed by the school to the pupil. And then at the end of the same paragraph, where I could agree with the claimant on a case-specific basis is that there may be cases where the same circumstances which would trigger Article 4 protection duty have become an obviously relevant consideration to which regard must be had by a school in making a PECS decision. So it is a part of those considerations. And the good news is, I know that Ollie has spotted that some IRP, some of the organisations that are involved in facilitating IRPs have started asking whether or not there are signs of CCE before a child has been excluded. And that's obviously a really good positive step, if not quite a small step. And I had a case in which a young person was reinstated specifically because of this judgment, in which the school said, because they had, in that case, a conclusive grounds decision, they recognised that he needed to be reinstated under their protection duty. So that's the good things. The bad things, unfortunately, for this claimant, and I think this is frankly outrageous, given the warning signs that were there, was that the court decided that the threshold was not met in that case, which is obviously a fact-sensitive assessment, but given the facts that were there, I thought was completely outrageous. There was an appeal, but the appeal, unfortunately, was also unsuccessful, and the court gave not only very short shrift to the claimant's arguments. In a 22-page judgment, there was less than half a page of discussion, which was, the court went so far as to say, and not only is this a case where the court had the discretion to find the threshold not met, but if the appeal justices had the question before them and whether or not they were making the decision anew, they would also have found that the threshold was not met. So that was really, really frustrating. And then just to sort of rub some salt in the wound, twist the knife, they also said that the best sentence that Mr. Justice Fordham wrote in his judgment was that one I read to you earlier, said that he could agree that the GDP could not fail to reinstate if by the time of the reconsideration or of reinstatement an HRA duty was owed. They said that that's not correct. And actually they don't think it's correct that if a duty is owed, that the school has a mandatory obligation to reinstate. And with all that being the case, it brings us on to the next step, which is, where do we go from here? And I know that there are some solicitors in this room who are already doing work on this. And the next logical step is, well, we know now that the principle exists, but what protective duties do schools owe to young people who are at risk of exclusion or who have been excluded or going through the process of being excluded, particularly if the courts are saying, well, it's not to reinstate them necessarily. What is it? What considerations do they have to have? And I think a really interesting question arises out of RWU, because in RWU, one of the things that Mr. Justice Fordham noted in his consideration of whether the threshold was met was the attitude to the claimant of other services. So for anyone who doesn't know, not anyone can make a referral to the National Referral Mechanism for a decision to be made about whether or not a child is a victim of exploitation. Only designated first responders can. And in this case, for example, social services are a designated first responder. And Mr. Justice Fordham said, well, they didn't make a referral to the National Referral Mechanism, and so why should the school have been obliged? Why is it that they ought to have known that he was a potential victim if social services, who are a designated first responder, didn't? And obviously we say, well, the school is uniquely well placed to know. And the fact that it's not a first, perhaps it should be a first responder, but the point is they can't be blind to what they know because another service hasn't responded in a way that we think they should have done. And so I think the question arises, what does a school do in future if they want to exclude a child who they think is the victim of modern slavery, but where other services aren't responding either because there is some kind of bureaucratic obstacle or because they don't agree that the threshold is met, but the school is convinced that it does, particularly when, again, just to reiterate, the outcome might be fatal for the child or young people. And even if it isn't fatal, a child or young person going to prison for something that happens as a result of the school to prison pipeline because they lose that protective factor is, of course, a life-destroying tragedy in and of itself. And so I really hope that that question is put to the court and put to the court quickly as to what duties are owed under the positive obligations under Article 4, particularly when a child is at risk of permanent exclusion. And hopefully we'll have a role to play in making sure the answer is a positive one. Thank you.
And I just want to say again, as you can tell, that was a really important series of cases where significant principle is being litigated and exposed in the courts, and actually it is really quite shocking when you put it through a different lens, that we have recognized that these children are targeted. And although in this case, in this applicant's case and appellant's case, this wasn't a particularly vulnerable child in terms of their susceptibility to being exploited, because they may have learning needs in order would make them more likely to be coerced by the sophistication of that gang exploitation. That's what we see, a really strong overlap between underlying SEND needs and their targeting by these particularly currently-loving gangs. So the fact that schools should be there protecting them is even more important, and that this is recognised by schools. So yes, a question there.
It's not really a question, it's actually a couple of observations, because last year we represented a child who I now recognise could have been a victim of CCE. He didn't look like a typical child that would have been picked for that. He was a white Turkish Muslim, and he was bullied and threatened with a knife into selling drugs in the school, and was initially permanently excluded. But because his mother was amazing, she managed to find proof of the bullying. And the weird thing was, in relation to schools, teachers are trained to look for signs of abuse and exploitation. So I think it's crazy that they're not first responders, or that they're somehow absolved from that mechanism. And in our case, we were lucky because our advocate was a trainee lawyer and they made procedural errors. So we were able to get that case overturned. But this child was suicidal and could very well have ended up dying or ending up in prison if he didn't get the help. So it's really, I'm really interested to know what's going to happen, because it is a lot more prevalent than we think it is.
Yeah, thank you so much for sharing that example. And we have another contribution from the person sitting in front of you.
I've been fortunate enough to have Ollie represent my son. He still continues to do so, and without him and CEN initially, I don't know where we'd be today, but it's been a real struggle. And I think our bigger picture is just to visually kind of call out at one point is actually what an absolute crisis the mess the system is absolutely in. You know, I didn't discover CEN or the school inclusion project until the 11th hour, and it was literally like a week before we'd get to the Central Tribunal. I had contacted over 17 legal aid solicitors, you know, twice, 3 times in some cases to try and get access, couldn't get anything. And so my son was permanently excluded, thank you, but my son was permanently excluded twice in year 7 for behaviour related to his needs. The second involved him being physically restrained by 4 adults after incidents of bullying had not been investigated. My son had not been supported. We've got to the Central Tribunal. We've now put in a subsequent human rights claim with the school. I've now discovered a catalogue of failures from Hackney. We're all from Hackney today. Hackney have now taken prime position of the worst level of exclusions in inner London. It's an absolute tragedy because of its history in Hackney as well. We should not be here. If many of you know that we went into special measures as a borough about 20 years ago. I don't understand why we are where we are. We've had 2 very serious case reviews of child Q and child C. Child C was a child who was unlawfully permanently excluded from school, and as a result, a serious case review determined that if he hadn't been excluded, he was basically stabbed to death. And if he hadn't been excluded, he would still be alive today because the exclusion exposed him to this new level of vulnerability. My question is, so, you know, Shaun spoke about changes from statutory guidance, which I would love to see. Much of the things that were chucked back at me. So my son has an EHCP, he has autism, an ADHD, and he hadn't had an annual review for over 18 months. His needs had never been scoped for secondary school. I can continue with the catalogue of failures that are here. But my overarching theme of what I would like to see is actually some changes in the statutory guidance, because one of the things that came up for the independent review panel is that the school only should have done these things rather than must. It felt like it was an option. It was their get out of jail card, quite frankly. And one of the things that came up in the child Q review, which then touched on child C, was about, and this is where I'd like to know from you today, is about the actual Children's Act, from the Working Together to Safeguard Children document. And we're talking about, you know, multi-agency work, you know, the spirit of the Children's and Families Act, you know, the Equalities Act, etc., public sector equalities duty, is there is a power, seemingly, that the local authorities can compel safeguards and relevant safeguarding partners to work together in the interest of a child. But I've never seen that duty be applied. It's something that Jim Gamble spoke about in the Child Q review. It's something that Hackney just seem completely, they have spoken formally on record. In a cabinet meeting, they spoke about that there are powers. I've never seen them access it. You're Dan, are you Dan? Yes, I've reached out to you before. I watched you at 4 o'clock in the morning of a webinar actually from Garden Court. And basically, but I've never seen a local authority access those powers to work in the interest, and especially in the context of academisation as well. In Hackney, out of the 16 secondary schools, 15 of them are academies and voluntary aided schools. So therefore, the local authorities say, well, we can't do anything, but there must be something.
Alex, do you want to come in and try and respond to that? And if in your answer, you can be creative enough to also to respond to one of our online questions, which is about there is perceived to be a hostility from mainstream schools about being inclusive and a demand for segregated schools, or may also be described as specialist schools. How can we challenge these exclusionary practices and advocate for inclusion of disabled
So just one more point to add though. Sorry, there was a lot. So again, for broader context of why I've come into the local authority, is because in my son's case, the first exclusion was converted from a suspension to a permanent exclusion, then rescinded. He was left around the education. The second, the initial SDC was delayed from 15 school days, the mandatory 15 school days, to 4 months. It seems like the whole statutory guidance was completely disregarded. Even today, I'm supporting a parent who's waiting for an IRP 6 months after the exclusion now. So it's like there's zero enforcement, there's zero regulation from anyone to ensure that everyone's doing the right thing. Yet families and children, crucially, are expected to conform to behaviour policies, but the same kind of mirror of behaviour policies, which is essentially guidance for schools, the schools are completely allowed to disregard. And I don't see how that is possible.
That's really a really good point. And I think I'll start with the point online, because that's a good preface, which is about attitude. So I used to work in education policy, and Sabrina, you'd probably be able to add to this better because it's been a little while. But one of the things that I took from that is that the head teacher's lobby is very powerful. And there is a perceived hostility to children in the permanent exclusion process because it's an actual hostility. It's the system we all know is geared against them. That's why it's a system that through those stages, the GDP, IRP, and then reconsideration, you know, you're very, very unlikely, well, often not hugely likely to get reinstatement, and the IRP obviously can't direct that reinstatement. And I think part of the problem is the argument you always get in every single exclusion, no matter what, is fine, you know, fine, maybe your child is vulnerable, but what about all the other children I've got to do with? It's every single time in judicial reviews everywhere. And so it's like, well, you know, kind of tough luck really, because the balance is a zero-sum game. It's like, it's all or nothing. It's either we owe you the duty, you know, like we were trying to argue in RWU, and therefore they need a place in school because that's where they're protected. But if we think that the balance is tipped in favour of the school community as a whole, then you're on your own. And I think the second point there is we all experience in so many areas of judicial review against authorities like local authorities and schools, particularly in where there's a competing safeguarding issues. Often the defence isn't that the child doesn't need safeguarding, but it's where that duty lies and who's going to take the steps to actually implement safeguarding. And again, in schools, what they often say is, we're a school, we're an educator, and we've taken on more than we're supposed to have in terms of safeguarding, etc., etc. And I would say, and it sounds like maybe you'd agree, the problem with that answer is that schools are uniquely well placed. You can't replace that, the level of expertise they have, as unfortunate as it is, by moving the duty to the local authority, because it's the schools who know the children best. And it's the schools who are going to have the most contact with them. And also it's a healthier relationship, generally speaking, than a social services relationship, which can be so very fraught, particularly when social services be someone that a family is scared is going to interrupt the dynamic. But I think that's unfortunately the where we are. And I think the difficulty is, as you've pointed out, is the guidance is particularly helpful and potentially moving in the wrong direction. Because you add on top of that, that the schools have something, a lever that the local authority doesn't have, which is this country's increasing focus on behavioural responses, tolerance of isolation, detentions, fixed term exclusions, and where the answer for children who have disabilities or who have other risk factors like CCE is we'll reduce, go from a week-long suspension to a 3 working day suspension, as if that's any kind of answer whatsoever, instead of, okay, right, well, the suspension isn't going to be an appropriate measure here, but there is obviously a safeguarding need. I don't, unfortunately, I don't see it getting much better anytime soon.
I wanted to add to it. There's things that I'm aware of. There's an Alliance for Inclusive Education. They've actually got a working group that's looking at how inclusive mainstream schools are for special educational needs. They're totally against special schools because a lot of parents think they're one size fits all and they're not. So they've got a working group to lobby the government to make mainstream schools more inclusive for special educational needs. And the second one is, I think more parents need to be governors. I was a chair of governor for 8 years, and in our school, the send-off was awful. So I recruited a governor that had special educational needs background and training, and between us, we managed to change the whole send-off in our school. It was all through school on 2 sites. So we had someone with SEND training, with SEND qualification on the primary sites, and an overarching person on the secondary site, and it went all the way through up to governorship, so that our offer for special educational needs children was better.
Amazing, well done. Sorry, Sabrina.
I just add, sorry, thank you for sharing your story. I've heard many parents cry down the phone to me, and I've witnessed the trauma of what families have been through. I don't know if you was here when I shared at the beginning, but none of us can be silent on this, whether we are online listening to this or we're in the room today, because I am yet to see, within my years of doing this work, a school exclusion where the school has followed its behaviour policy and followed the school exclusions guidance, and they've excluded a child. I'm yet to see that. We've got, I think heard a report today, we've got an increase in children with special educational needs, particularly ADHD. I've checked the stats, and last year we had record children excluded, not over 9,000. Yes, we have academies who have additional powers. And in addition to that, we are going to see an increase in school exclusions by the time we get to these annual statistics. We're seeing an increase in children who are being groomed into child criminal exploitation. So this space is really important, because we all can do something when we leave this room. And I don't have all the answers. I know that obviously we have just done this case, which we are just now ready to start doing more exceptional case funding applications. And that is to be so that we can scrutinise school exclusion hearings. Most parents, local authorities no longer come to them because they're academies. That means most children, families like yourself, sit in these hearings, and I've heard awful stories, and who is there to regulate whether that school exclusion was lawful? Or that the governors knew what they were doing or asked the right questions. And nobody, we just see the stats.
And I don't know who else's child has been excluded, but the level of harm for us, like, you know, my son was left without any education for 18 months. I mean, in the whole 2-year duration, he only had 16 weeks schooling. I had to give up my employment January last year because I believed that he would have been highly vulnerable going to a PRU setting. My daughter was victimised and had to move schools. She was left without the education for a year. She had to move schools, go back a whole entire academic year. So she's now doing her GCSEs, and she's found that challenging because the GCSEs, she's all great for grade 9s, etc. But now she's held back because of her age. She can't get into particular sixth forms that she's wanted to move to because she should be in the year above. It's had a disastrous impact on us, and that's what I would really love to see, is much more earlier intervention as well. It's fantastic that this ECF work has come through for an IRP. As I've said, you know, for us, I mean, for the family, even today I'm supporting, they've waited 6 months for their IRP. You know, my son's incident from the second school was in May, 18th of May. The IRP didn't happen until the 14th of November.
Absolutely, there's a systemic issue, and there are multiple flaws within the school exclusion process, and we are going one step at a time. This case has opened doors, but within the learning within schools, also when lawyers will be able to be in a position to say, actually, you should have done this. I've sat in hearings where said experts have said, school, you need training around this. So there does come the learning. I think it's really important that your stories don't go unheard. Now, I don't know, you know, whether that's lobbying, whether it's going to the DFE, and being a case study and being open to that. They need to see, because we do know, obviously, that, you know, a school exclusion doesn't just happen to a child, it happens to a family. I've heard many parents like yourself talk about the long-term impact, mental health on you, on the family, job, etc. That then happens to a community. The long-term impact and cost, nobody really is calculating what that does to us.
Especially school now, it's £109,000 a year they're paying for.
And all the missed opportunities that were made because there is not enough investment in early intervention. They say, and we all know, early intervention is the key, because in that way, when a child is supported, I think we will see a lot less children having to come through on high needs and educational healthcare plans. but we have to go one step at a time. Obviously, each of us have different roles within this room, but what I said within when I did my talk is we cannot be silent.
And thank you so much for sharing, and to everybody who has contributed to this evening. And I think really each last discussion has really illuminated how pressing the issues are, but actually there are opportunities for us to make a difference. So let's continue the discussion. Thank you so much for the panelists, both in the physical room here and in our virtual room across the country, whether interrupting their holidays or otherwise. We're extremely grateful at Garden Court, but we're also extremely proud of the fact that we are supporting this community, and we'll do so downstairs. Thank you all for joining us online. I'm sorry you can't be here in person.